Good evening, everybody. It's 7:34. I'd like to call to order the March 12th, 2026 Old Bridge Township Special Planning Board meeting. Please rise for the pledge. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, Daniel, please.
Mr. De Palma?
Here.
Mr. Lenning is absent. Mr. Talamo?
Here.
Ms. Cannon? Mr. Brenna is absent. Mr. Petty?
Here.
Ms. Masella? Here. Mr. McIsaac?
Here.
Mr. Brennan?
Here.
Mr. Ferrara is absent. And Chairman Lauer.
Here. Okay, swearing in.
Swearing the professionals, we have our planner here. Ms. Swan, would you please raise your right hand? Do you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth? Thank you.
Okay, we're going to go into executive sessions. I need a motion.
Second.
Mr. De Palma?
Yes.
Mr. Talamo?
Yes.
Ms. Cannon? Mr. Petty?
Yes.
Ms. Masella?
Yes.
Mr. McIsaac?
Yes.
Yes.
And Chairman Lauer.
Yes. Next, we have the adoption of the 2026 Planning Board Rules and Regulations. Has everybody had a chance to look at them? And, okay, the first one with changes, 1:1-5.
I thought we were moving that to the next session when we had more.
Well, I think we got enough now, that's why, I'm sorry. Okay. So, under the secretary, the removal of a couple line items on that, I don't have a problem with that. Is,
Mr. Chair, can I, may I ask, Dina, would you be able to just outline some of the changes? Because I think looking at it, it wasn't so much changes. Is it just rewording and just kind of cleaning up some of the language? Because there's no material or any change to any of the boards. It's just taking out certain things that aren't applicable.
well, one of the main changes would be the time. We have to discuss that.
But the time hasn't changed.
I think that, no, I thought that was changed. It wasn't changed. It was the thought, but it's staying at 7:30.
Well,
Time of-
in the copy that I received, it was,
This is not,
it was marked, here, it was marked. Oh, okay, it was, oh, okay.
going to be changed.
Oh, okay.
yeah,
Change it back.
Okay.
Yeah.
yep,
Okay.
so there is no substantial change. It's
Right.
just that some of the terminology, like the clerk, secretary and stuff, there
Right.
were strike-throughs.
Right.
But the only change actually is the timing, that we are limiting residents that come and speak. But other than that, there is no change to the document.
Okay, the time was going from 5 minutes to 3 minutes,
3
right?
minutes, yes.
Okay.
After everyone is done speaking, the ones that that have already spoken can come back with new questions. But this is only because we have bigger applications that are going to be coming in front of the board. And I know there will be a lot of public participation, but to be able to give everybody a chance, if we're giving 5 minutes, we'll never be able to finish. So we want to restrict it to 3 minutes. Yes, yes.
Okay, so on the 2:6-4, under the electronic evidence, there's a line you're taking out, am I correct?
Yes, which only clarifies that, because I know there were some emails exchanged about getting paper copies. This, if you look at the section, it specifically talks about the exhibits that are introduced during a public hearing. So if there is something that is produced by an applicant digitally, the planning board has the ability to ask for a paper copy, which typically they do. A applicant who comes in, if they have an exhibit, because they are allowed to submit exhibits 3 days before the public hearing. So those exhibits, typically, they would carry copies and distribute, but if they don't, the planning board has the ability to ask them that, okay, at the next hearing, please provide us paper copies. So it was just a clarification, because I believe there was some confusion about the language.
Well, the way I read it, if you take out that last part of that sentence, and it says that the board member, the applicant document shall be provided to the board member by the applicant, period.
Yes,
The board member can't get it unless it goes through your department.
no, this is at the meeting. the board member can ask the applicant directly for a paper copy to be provided at the meetings.
Well, that was not the intent
But-
of that.
No, the whole section is about evidence. Evidence is produced at the public hearing.
Yeah, but
The whole section talks about digital submission at the public hearing.
paper copies or plans or other application documents of, of evidence, see, that's new, isn't that new?
It's not new. That was the intent always, because it is electronic evidence which is at the meetings. So it only clarifies it further because of some of the emails that were exchanged about paper copies. It's not really changing anything. It's just making it more clear. It just says in the language that application documents of the evidence provided at the hearing. It only makes it more clear. And the planning department would not have those paper copies anyways, because it's evidence that is produced at the meeting. So it has to be the applicant who provides you with that copy, not the planning department. The planning department is only taking 2 paper copies for any project. We are not asking, or if it is going to outside consultants, or like, for example, the forester wants a paper copy, or the fire official wants a paper copy, only then we ask for paper copies. The planning department only asks for 2 copies, which is required by law. One, we have it for file, the other one is for public review or for planning board review. And this is a change that is coming about in all municipalities. It's a statewide change that even now noticing requirements are digital. So I don't understand.
I think I can explain, Mr. Chairman. I think I recall, because I'm going through my old notes. We actually added that paragraph in last year, or it was a year and a half ago. And that was being added at the time, because I remember having conversations with the chairman, because the issue was if we got, everything's being submitted electronically, but if the board for a specific application or a board member said, well, I know the application plans were submitted electronically and we can get them electronically, but I need, not an exhibit, but the actual plans or other document, I need a paper copy of that. And so the intent was for that amendment to allow for a planning board member to go to the planning department and say, we got this application coming up, I can't review this electronically, can you ask the applicant to get X amount of hard copies for us? And then that's why it was going to go through the planning department, because I remember I drafted that language. But I think and I might have accidentally put it into that section where it's evidence, because it wasn't intended to be for exhibits, it was intended to be for the actual application documents in case a board member asked for paper copies. So I think that, and Chairman, that's why I think why the disconnect right now is because that language was supposed to be for application documents, not for exhibits.
Right, but because it says evidence,
No, I know what you're saying, but I
Right,
think what the
so-
chairman's going to want then is to, and I don't mean to put words in your mouth, is then to add some language somewhere else in the rules to allow for that original intent, that the
I mean,
application documents, it can be requested in paper from the applicant and certain, when requested.
I mean, I would request to carry this, and that is exactly why we were trying to carry it to the next meeting, because townwide, we have made that decision that we're not going to ask for paper copies. Because what is going to happen is I will be dealing with now individual requests from board members to get paper copies from the applicant. And we're so busy right now that it really takes up our time and it takes away from the purpose, because if I'm doing it for one person, I'm doing it for not just board members, planning board members, but also zoning board members. If the council has made the decision that we are going digital and have everything digital, there is a paper copy available in the planning department to be reviewed by either public or the planning board. And I've made this clear numerous times that between our office hours, any board member, any resident can come and review those applications. It is physically not possible for us to provide those copies, or even for that matter, it is difficult for any board member to review it. For example, planning board deals, in fact, zoning board, it's slightly easier because their applications are not that big. In the past 5 years, the applications that planning board has reviewed are 100 pages, 150 pages. My office is flooded with paper rolls, and all I do is I take those and throw out. So now we strictly tell the applicant, do not submit paper copies unless we ask for it, because we keep getting revisions like tiny changes. Again, I have 105 paper copies. And I mean, we have an environmental commission. We're trying to save trees and we're throwing out so much paper. So that it's a conscious decision. It's a decision by the state. Old Bridge is not the only town. Many of the municipalities have gone completely digital. I know of some municipalities that are not accepting paper copies at all. And that is precisely why few years ago, the Township Council made a decision to get the surfaces to every board member so that they can review it digitally. The IT department is actually working on getting the surfaces now replaced with tablets, and that should be coming up soon. It'll be much better than using the surfaces, but that is the intent. So I am not too certain. I need to discuss it again, but I foresee a lot of problems in changing the language. So I highly recommend the language be the way it is. Paper copies are available in the planning department. It's not that we don't have paper copies, but I promise you, it will be even hard for you guys to take it to your car. Those rolls are that heavy. So
So the intent of the change, Dina, was just to make it that when an applicant comes and submits new evidence, which, we're marking sub-exhibit A, A1, so on and so forth, that upon our request, that they have to give us paper copies,
that is correct.
right? So, Joe, does that read that way?
Yes.
As the attorney?
Yes.
All right.
No,
Attorneys could read things a lot differently than I can.
No,
That's all I
that's
can say.
exactly how it reads
Okay.
and how it's in this section. I just was going back on, trying to clarify the confusion between the chairman and Vina
Okay.
as to, because I do recall coming up with the original language, but in the original language had a different intent. But that's how it reads, and that's how it is in the current draft right now, and how it will proceed. Now, that ancillary question is to, whether the prior intent in the prior amendment wants to be readdressed, and as Vina gave
I
a very
would-
good explanation, that's
Right.
a different topic.
I would request that the prior agreement be revised to take out the word evidence.
But that also means that the planning board can can request paper copies, which is not the current policy of the township.
Yeah, I understand that, but the applicant's the one that's supplying the paper copies, right? The applicant bears all the expense. All you're doing is taking it from the applicant and handing it.
It's not about, it's not, you're missing the point here. It's not about the expense to the applicant. It's the volume of paper that is coming in, and it takes away from the intent of going digital. Because if we are doing it for one person, we are doing it for, I cannot pick and choose that, okay, I do it for the chairperson and I don't do it for others. So if it is something that has to be done, it has to be done. Then I might as well ask applicants to submit 15 copies and distribute, have every board member come and pick it up from the planning department. It doesn't make sense to me. But again, I will discuss it with the administration. I'm not in favor of it as a manager of the planning office, but again, it's not solely my decision. I will go back, I will discuss it with them and get back to you guys.
Okay, so we can vote on this and maybe hold off on that particular section?
Well, no, I think, Chairman, this section, the way it reads is exactly how it, Vina was reading it, is
Right.
that this applies to electronic evidence.
Right.
Meaning the evidence provided at the hearings. What would end up happening is if Vina comes back and the administration says, yes, we're okay with going back to paper copies, or however that conversation goes, it would be actually a different section. It would be probably better under Rule 2-4 applications, where we add a new provision there. Because while we included it here back a year ago, it shouldn't have been here. I'm realizing when we're reading it now, we're going through it, it should have been in a different section. It should have been in probably section 2.4, we talked about.
And that is precisely, since it was said, evidence provided, that's how I read it, that it was
And you're
specific.
reading it correctly.
Right.
Okay, but it's going to be a rare occasion. I believe. I don't believe it's going to be everybody on the board wanting a copy for a set of plans, but it might be beneficial to a planning board member that wants to make a on-site inspection.
With 105 copies?
Vina,
I didn't get it.
What the chairman is saying is, in his, how he views it, how it would work, is that it would proceed exactly how it is now, and how it's all electronic, all submission. But if it's 30 days, 20 days before an application's being heard, and one of the board members says, I'm requesting a hard copy, then the planning department will reach out to the applicant and say, we need one hard copy. One planning board had requested it. And it would come back, you would get it, and then you would give it to the planning board member. And it would just be for that application, for that one planning board member. Now, the problem is, I can see where your concern would be is, well, you might get, the chairman may ask on the 21st of May, and then another board member is asked on the 23rd, and another board member is asked on the 25th, and now you're going back to the applicant every time, and it's becoming so that's an issue that we'd have to, if it went forward, that's an issue we'd have to address and try to figure out how to handle that. But I think that's what the chairman is asking, not that every application you have to get paper copies and give it to every applicant, every board member. It'd be on if a board member asked for it, and it would just be for that specific application, it would just be for the board member that's requesting it.
Right. I mean, I think either we do it with all applications, have everybody submit 15 copies, so that I'm not doing the back and forth.
I get that.
Right? Or nobody gets it.
So-
Because it's not that there is no paper copy. And it's now, I mean, I've been arguing and explaining this for the last 8 years. So it's a little bit frustrating for my staff too, because it's not, again, I'm saying, it's not that there is no paper copy. There is a paper copy. I know some board members who regularly visit the town hall. So they are free to come in anytime. We have never denied anybody, because we have residents that come in and ask for inspection of these paper copies. If a board member tells us that they're coming at so-and-so time, we'll make the conference room available. But to have language in the bylaws that picks and choose and gives that option, I wouldn't do that. If that's the case, I would just ask for 15 copies, have each one come in for every application, pick it up from the hallway, and be done with it.
So Vina, you know how I feel about paper. I go into your office and I get nervous the amount of paper that's in there. So I'm one of the people that'll probably never ask for paper. I'm probably the only desk in my office at work that has no paper. But what's the intent of us getting it? So, Mr. Chairman, it would be for you to review and ultimately then bring back, right? So you would ask for the paper copy, and then if you were to do a site visit or whatever and you want to review it, but it's not that you're going to be keeping those things home. It's just that you want to be able to review the large copy, right?
Right.
So not an essence to keep it. So what if we would just make it that you have to provide you have to at least provide one copy. That copy stays in the planning office, is
Which is
at the disposal of the board members, or even if a resident wants to see it, and that's it. We have one copy only.
We do have that because
Has a copy.
Okay.
we do have a copy because we have a copy on file. We have another additional copy that we keep. So
So we have the copy, so it's not that if Mr. Lara wanted the copy. Yeah. You could find your, you could find your
that's
way
why
through the
we-
office with all that paper?
So, but Barbara, respectfully, I know you have complained about nobody being in office, but you just think about the workload. You see all the development that's going on. In the last 7 years, Old Bridge has built like no other municipality. We are so busy, and people they have the right to take vacations, right? So we try our best, and that is why I keep saying just make an appointment, send an email that you're going to stop by at this time, and I will make sure there is somebody. I'm always in the office, I'm always there. Danny is here from 7 to 3. Yeah, it's just proper communication, and we'll make it happen. There are paper copies, and like I said, if somebody wants to inspect it, there have been times when we have arranged it in the conference room that planning office has. So you can spend an hour, 2 hours there and look at the copies. But trust me, those paper rolls are so huge that we don't want to see it even, because every day we are getting deliveries. And we have not just active projects that come in, like not active, new projects that come in that are coming in front of the planning board. But once you guys have approved it, it comes back to my office for compliance review. When it comes for compliance review, guess what? I'll give you an example. Segme Retail. Right now, they are on their 26th revision. Every time there is a revision, they send me those many paper copies. So now I literally stopped, and I'm not trying to save the developer money. It's his money. I'm trying to have less paper and stop wastage of paper, because for that one revision, if one word has changed and I get 105 pages, all I do is I note the one word change and I toss off
So,
the
Dina,
105
So
pages.
let's just. Play.
Yes, correct. And it's always there. Yes, and that is available in
is
the
there-
office.
So obviously keeping the copies, and if there's revisions, they got to send another one. Could they just send the revised page
So that's
instead of all of them?
so what I do.
Because I'll be honest, it's ridiculous. If there's a 100-page document and page 94 changes, just send me page 94.
So, I mean, I'm trying my best to work with them. So, what I have started doing, and ERI has been very cooperative with it, we ask them to send us PDFs first. I review digital copies first, only when I'm okay with it and I am ready to get the plans signed, I ask them to send me paper copies. Otherwise, the planning office would be flooded with papers.
Mr. Chairman, maybe my suggestion is, and I think working off of what the councilman was saying, is we can move forward with these revisions as we're discussing now, but with regard to paper copies, maybe what we look into is not necessarily having additional application documents being provided upon request, but maybe we have, because I understand that the intent is maybe you want to take them, not just review them in the office, but maybe take them with you when you go by a site, is maybe we have, and we can talk, I'm just talking, we'll talk offline as to specifics, is a way of having an extra copy that can be signed out only by board members.
Okay.
Board members can sign them out, you take them with you, you review them, you do what you need them, you bring them back to the planning office to sign them in case another board member wants it. So it's not, that way it's clean, we're not one-offing numerous times, and we're having a process where the board members can actually take them with you.
Okay.
But that won't be in this, because we won't
Right.
be able to amend that right now. That's something we need to work out specifics, but that's something maybe we can figure out offline.
Okay, that's a very reasonable solution.
I try.
Thank you for that. Okay, so the hours stay the same, correct? 7:30?
Yes.
And only for other, just cleanups, and the speaking time goes down to 3 minutes.
Yes.
Okay, so,
And Mr. Chairman, the only, you actually pointed out to me, the only other amendment we should probably add in there is under the order of business. After roll call, we do the swearing in professionals now. We should probably put that in there.
Yeah.
1:2-4, order of business. We should probably just add in between roll call and approval of minutes, the fact that now we swear in the professionals. It's a good practice that we've started to do in here, and it's probably good to keep it in our rules as well.
good catch.
It was your catch, Mr. Chairman. I'm just reminding you.
Okay, do we have a motion?
Move it.
Mr. De Palma?
Yes.
Mr. Talamo?
Yes.
Ms. Cannon?
Yes.
Mr. Petty?
Yes.
Ms. Masella? Mr. McIsaac?
Yes.
Mr. Brennan?
Yes.
And Chairman Lauer.
Yes. Okay. Next discussion, 20-2035 amended housing element and fair share housing plan. Vina, you're up.
So, good evening, board members. I was here in front of you June 26th to present the housing plan, and here I am again. I believe that I just want to give you a background history of how this started for some of the new members if they haven't, if they're not quite familiar with the affordable housing obligation that the township has. So on your screen, right, the Mount Laurel Doctrine, the obligation for New Jersey municipalities to provide affordable housing dates back to the landmark Mount Laurel decision by New Jersey Supreme Court, which established that every municipality has to provide a realistic opportunity for its fair share of the regional need for low and moderate housing. In response to this, the New Jersey legislature enacted the Fair Housing Act in 1985, which created the Council of Affordable Housing and required that all municipalities adopt a housing element and fair share plan as part of the master plan. As you are already aware, a master plan document is a function, or approving that is a function of the planning board. The housing element and fair share plan, again, becomes the responsibility of the planning board. The township, Old Bridge Township, fully complied with its first round and second round affordable housing obligation, which was pre-1999. The second round obligation for Old Bridge Township was for 439 units. Old Bridge at that time produced 586 affordable units with a surplus of 147 units. Then came the third round. On July 7, 2015, Old Bridge filed a declaratory judgment action seeking court approval of its third round plan. The third round affordable housing plan was approved by the court on June 19, 2017. In third round, the township's obligation was 1,396. The township satisfied this obligation through inclusionary housing, through projects that are under construction that are complete. Some of them have received planning board approvals. You are familiar with the Alfieri site, which was the last one that came in front of the planning board. The fourth round now. On March 20th, 2024, Governor Murphy signed a new legislation referred to as the amended law, creating a framework for the fourth round. In October 2024, DCA, the Department of Community Affairs, published its report assigning Old Bridge Township a present need of 318 units and a prospective need of 685 units. Key provisions of this amended law was it abandoned COA and it transferred the duties to DCA. It created an affordable housing dispute resolution program to manage any disputes and mediations. It required municipalities to adopt a housing element and fair share plan no later than June 30th last year. Old Bridge Township accepted DCA's present need, which was 318, but challenged the prospective need, proposing a much lower figure to 325 based on the local land capacity or the vacant land analysis. Challenges were filed by Fair Share Housing Center, proposing 745 units as their number, and NJ Builders Association with 685 as their number. Through hearings and settlement conferences before the program member, Honorable Judge Mary Jacobson, retired, the parties negotiated. On April 7th, 2025, Judge Jacobson issued her recommendation establishing Old Bridge's prospective need at 673 units. This was accepted by the Affordable Housing Judge on April 24, 2025. Old Bridge Township adopted its fourth round housing element and fair share plan on June 26, 2025, and filed it with the program the very next day. Following additional challenges by 7 interested parties, the township reached mediation agreements with Fair Share Housing Center and confirming the obligation and a path to compliance. That was done in January 15, 2026. I hope my dates are right, Joe.
I think the mediation agreement was prior, because we entered that prior to.
We did it before, but I think the official,
They accepted it.
yes. So on February 3rd, 2026, the program members granted a conditional compliance and directed Old Bridge to adopt its final amended housing element and fair share plan by March 15, 2026. And that's where we are today. So now, fourth round compliance, like I mentioned before, the present need is 318 existing substandard housing units occupied by low and moderate income households that require rehabilitation. We have an active rehabilitation program, and we, on an average, have rehabilitated like 5 to 6 units every year. We have funding in the Affordable Housing Trust Fund and CDBG grants to support this program. Prospective needs, the adjusted need is 673 units. So this plan proposes to have 853 affordable housing credits, which is a surplus of approximately 180 surplus credits that goes on to the next round. There is also 3 additional sites, and I will go through each site in detail, but there are 3 additional sites that can fetch us additional 60 credits, a minimum of 60 credits. This is the rehabilitation program. I already spoke about this. The township council has adopted a resolution committing to bond for any funding shortfall, ensuring that the rehabilitation obligation will be met. What happened? Danny, this is stuck. The prospective need, it's really hard to see this table, but this table is provided in the digital copies that were posted on the planning department's website. But I'll go through each of the sites. There are 14 sites that help us meet our obligation. There are 3 surplus sites which can become a realistic development potential, but as of now, they are not. So we have included them as surplus credits or surplus rights credits, which will come to fruition in the future. So, okay. This is a map that really shows the sites that are there. The area. It's just to give you a context, but I will go. I will have a enlarged version of each site in the next few slides. But the areas marked or the properties marked in yellow are the ones that are the 14 sites that help us meet the obligation. The sites that are in blue are the surplus sites, which one of them, no, actually, two sites are where the transit village is, just like Ms. Cannon had asked about the transit village. Is it one site? No, it's actually multiple properties that come within the half-mile radius, and there are two potential sites that will be redeveloped. There is one property that is owned by Woodhaven, two parcels actually, that are owned by Woodhaven on John Wall Road. It makes sense to include them as surplus sites because they were one of our objectives as well, but have backed out and are working with us to come up with a plan that works for the township as well. Now, the first site is Stratton Square, which is, as you all know, the summer site or the landfill site, the Old Bridge Municipal landfill site, next to the Cheesequake Park. They are working with us. In fact, we designated the area as an area in need of redevelopment. There is a developer interested in remediating the site because it's contaminated, but there is some clean uplands in that area as well, and wants to develop that site with 450 townhouse units. It's a combination of for sale. So 50% of it is for sale, 50% of it is for rent, but that gives us a good chunk of affordable units. And in fact, we will get 90 affordable units out of that project. The next site is the English Town Raceway Park. The planning board recently heard Sami present the plan. It allows the developer to build in up to 600 multifamily unit, not multifamily, it's a combination of townhouses, stacked townhouses, and multi apartments. But regardless of how many units they build, they have to provide 120 affordable units. So we get credits for those 120 units. The next one is the sites 3 and 4 are the site that K. Hovnanian is a contract purchaser. That is the only property where we are still negotiating because based on this plan and the density that we require to get a transit village designation, we have 30 units per acre, which means there will be 1,500 units, out of which 274 units would be affordable units, whereas there will be 26 special needs housing. The key point here is when it is a transit village, there is a development in transit village, the township is eligible for an bonus credit of 0.5 per unit. And if it's a special needs housing, the township gets one-on-one bonus credit for any unit that is built within a designated transit village. So we are still working, we're still negotiating. We have had a couple of meetings with the developer, and I think we are inching closer and closer to the goal the township wants to achieve. There is a potential that some of those units may be for sale. Not all of them would be rentals, but it's not something that we have really finalized yet, and that is why I will be coming back in front of the planning board with an amendment once we have a settlement with the developer. And at this point, if Joe, you want to add
Yes, Ms.
something.
Swan, if I
Yeah.
may just jump in, just for the public's and the board's edification. The reason why we have to still move forward with the plan, even though we're still negotiating with Kay Hovnanian with regard to this site and this development, is based on the court's order. The court order that was issued that accepted the settlement with Fair Share did set a mandatory deadline for adoption of the township's amended housing element and Fair Share plan by March 16th, since March 15th is a Sunday. While the township is given the ability to adopt a binding resolution acknowledging that it will adopt all required resolutions and ordinances implementing the plan at a later date, and we can just have to adopt that resolution by the March 16th deadline. The court order specifically did not include the amended housing element and Fair Share plan. So that is why we are still moving forward, even though we haven't fully negotiated all of the sites. We're going forward with what has been presented in the plan and what was included in the settlement with Fair Share Housing. However, as Ms. Sawant had mentioned, there's a good chance that we will be coming back for a further amendment once we, to the housing element Fair Share plan, once we get that being resolved. And just to make a side note, currently that is being mediated through the court's special adjudicator, and the court is maintaining jurisdiction over the entire township's fourth round compliance, so we will be having case management conferences with the court itself, with all objectors, including Kay Hovnanian, as part of that process as well. So I just wanted to note that for the record, in case there was any confusion as why the board might or the public might be asking, well, why moving forward now if it's not in the final form? It is in the final form, but we will be amending it most likely based upon the current negotiations.
Can I just ask something about the for sale? I mean, the for sale units would be a consideration to be included in this, in the affordable housing count? For sale units, like
Yes.
Habitat for Humanity builds for sale units, and they are within certain price range, and when you resell, it has to be within. We don't have anything like that anymore. We did initially, but I don't think we've had any recently at all. And I wondered if that's what you're talking about, something like that?
Correct. So we have been, even in the past, for some of the board applications that came in, right? We work with developers to ensure that if there are for sale units, there are some affordable units, because we're trying to create truly inclusionary housing. So to answer your question, anywhere there are for sale units, there will be for sale affordable units also created.
Okay, so people can sell the house and make within a certain amount, and then the
Correct.
next people in would inherit that same plan?
Correct.
Okay, all right, thank you.
So the next site, now the couple of sites that I will be talking about, they are actually either under construction or have been approved either by the planning board or the zoning board. So site number 5, which is Oak Tree Plaza, is actually a site that got an approval. It's a mixed-use development, has 36 apartments, 5 of them are affordable, and the project is currently under construction. Poor Farm Road, Site 6, which is again a site which is almost close to completion. No, in fact, they have been occupied. Some of the units have been occupied. That's Ryan Homes on Poor Farm Road. And that project has 35 duplexes, of which 7 are affordable. We get credits for those. Site 7, OBNJ LLC, it is an application that was recently approved by the zoning board, and that site has an existing mixed-use building with a retail store and 8 apartments. The owner came back to the zoning board to do a rehabilitation of the building and added 2 additional units to the building. So now the addition and the existing building together would have 10 units. they have agreed to have 2 of the 10 units to be affordable, and those will be deed restricted for 40 years based on the new regs. The next site is the Ferry Road site. These were Foxborough Ferry Road. These were one of our objectives, and we settled with them because the site, if you may recall, Foxborough had come in originally with 3 sites. 2 of them were on either sides of Foxborough Drive. One of them was the planning board application that was denied. And it went to the zoning board. The zoning board denied it as well. So they had initially reached out to the township to include 3 of their sites, but we agreed, or we settled to accept only development on this site. So I'm working on creating an inclusionary housing zone to accommodate townhouses here, and that would be 124 townhouse units, but regardless of how many units are built, so it's up to 124 units, regardless of what is built, 25 of those units are going to be affordable, and these are again for sale townhouses. Now, sites 9 through 13 are age restricted. First is Hanley Orchards. This is a project that was approved by the zoning board. It includes 58 units, 12 of which are affordable, and this site is currently under construction. Site 10 is Vision Old Bridge 3. It's on Old Matavon Road. The project is complete, and this has 48 units of assisted living with 10 affordable units, 6 Medicaid beds, and 4 age-restricted rental units. Vision Old Bridge 4, which the planning board recently approved, which includes 70 luxury age-restricted units. 14 of them are affordable. Gyke Park Residency, Site 12, which is a fully complete project that has 33 age-restricted units. 5 of them are affordable, and we get even rental bonus credits for this project because of its age-restricted status. The next one is an interesting site, and this is a site that was not included in the June 2025 plan that was adopted by the planning board. This is the Rotary Senior Housing, which is located at 100 Ticetown Road. So this project was built somewhere around the mid 80s, and when it was built, it's 100% affordable. It received Section 8 funding. There were 204 units that were built. So 203 affordable units, and 1 unit was for the super. But in the second round, only 110 units were included. And I was talking to our former planner who wrote the second round plan. At that time, there was a restriction on how many age-restricted units you could include, and that is why only 110 units were included. However, the entire project is fully affordable. This only came to our attention because a new developer who bought the project in 2018 is now seeking to refurbish the entire facility with newer amenities. They want to add like a gym, they want to add some computer labs, they want to add some recreation element to the senior housing center, as well as they are going to rehabilitate each of the unit with newer amenities. I've seen the pictures of it. It looks really fancy. But in order to be able to do that, they are seeking funding, low income tax housing credit funding from NJHMFA. Also, they are looking for a pilot program with the township. The township council has already passed a resolution in support of it. And so The remainder 93 units that were never credited for have been included in this plan because with the NJHMFA funding, these units are going to be restricted to affordable housing up to 2050. Up to 2050. So the township is then eligible for credits on that project. So that was the site 13 was a new addition. The next site is the, wait, did I go back? You know what, this is a wrong picture that was added actually. I'm sorry about this. But 308 Norwood Avenue, it's a property in the harbor area, which was built by Habitat for Humanity, where we get 1 credit, and that's again a for sale unit. Now, 3 sites were included as surplus credits. So with including these 14 sites, we have already met our obligation of 673. In fact, we have 180 surplus credits. However, Woodhaven had reached out to us with 5 sites that they own and they would want to develop. They were one of our objectives. We have rejected 3 of their sites because they are zoned for commercial. They were part of the original GDP, and we want to retain those for commercial. However, these are 2 parcels that are located on John Wall Road, and it just makes complete sense in terms of planning to include them because on the other side of John Wall Road is the Raceway Park redevelopment area. Woodhaven is willing to work with us. We have had a couple of meetings with them because they are interested in actually doing age-restricted housing. Apparently, there's a high demand for age-restricted housing in the township. Their project at the corner of Texas Road and Englishtown Road has been highly successful. There's a waiting time to get into that project, so they want to build age-restricted housing, but this time they want to develop a different style, and we're still talking to them. The one thing that we asked Woodhaven was that they include special needs housing, and they've never done it before, they wanted some time from us to get the details and see how they can develop the project to include special needs housing. So we are working with them, and that is why the site is included as surplus. So we'll definitely get some credits once we settle in with them. Sites 2 and 3 are 2 sites within the prospective transit village designated area. These 2 sites are actually owned by NJ Transit, and NJ Transit has been selling their properties to Economic Development Authority that is now redeveloping these sites to create more transit-friendly developments, and EDA is anxiously waiting for the township to pursue their transit village designation so that they can redevelop these sites. So that's why those 2 sites have been included, because at some point this year, once we have a plan in place, EDA will be redeveloping these 2 sites. So
Ms. Swan, if I may, just going back to the Woodmont site, just to explain to the board as well, Woodmont was an objector to our plan.
Woodhaven.
Woodhaven, sorry. They were objectors to our plan. As part of, and the reason, and another part of the reason why we're including them as surplus is they voluntarily withdrew their objection based upon being included in our plan as surplus. Working with the township on the future development of those sites, as Ms. Sawant has explained. So just if there's any question as well, you know, if we already meet our number, why are we including this site? Well, that is part of the reason, is because it is part of, and we don't have an official settlement, it is part of the reason, kind of a settlement and a resolution that they're proceeding and withdrawing their objection based on that being included as a surplus in future negotiations.
If we exceed our number, do we get credit next time around?
Oh, absolutely. Anything
Yes.
that exceeds, the question was if we exceed our number, do we get credit in the following rounds? And yes, the answer is absolutely. Any surplus, any number that's above our obligation gets carried over. And just to that point, we still have our appeal of the court's order designating the number at 763. Because if you recall, our number was, I'm drawing a blank right now.
325 something.
Yeah, 325, 324. So if we win on our appeal, we'll have a lot of surplus moving forward, and we may not have to plan for anything for the fifth round, depending on how that works out. But I just wanted you to be aware of that.
So now, in summary, as of December 31st, 2025, Old Bridge Township has collected roughly 9 million, expended 7, and the Affordable Housing Trust Fund has roughly 2.2 million. The accumulated interest income by December 31st, 2025 was roughly 800,000. So that's the money that we have in the Affordable Housing Trust Fund. We have an active program that we work on. All inclusionary units that are part of this plan will carry a deed restriction of 40 years for rental housing and 30 years for sale based on the new regs. Old Bridge Township is committed to adopting a model affordable housing ordinance recently approved by DCA, Fair Housing Center, and Affordable Housing Professionals of New Jersey. There is an Appendix M in the ordinance, in the plan, that actually includes a resolution. The township already passed a resolution showing their commitment to adopting the model affordable housing ordinance, the affirmative marketing plan, the development fee ordinance, and the spending plan in the coming future. The township has appointed a municipal housing liaison, which is me, and has retained CGPNH as their administrative agent to oversee compliance and monitoring. Based on the state regs, the township submitted our monitoring for the last year on February 15th. So I'll take any questions. Thank you.
Did Habitat for Humanity ever build their complex?
They are,
Habitat for Humanity was building something over in Lawrence Harbor, supposedly.
yes, they
That
are still.
completed?
No, they are not completed. They are under construction.
Oh, okay, so that will be, we can get
Yes.
credit for that, right?
Yes, that is
What
correct.
about,
But that goes to the third round. That was part of our third round obligation.
Oh.
We don't get credits for that in the fourth round. Because if you recall, that 12 units and the project Vista at Old Bridge that is on Marlborough Road, those two projects were part of our 100% affordable municipally sponsored projects, part of our third round. So we got credits for that in our third round.
oh, okay. And then just one other thing, the other senior housing we have, we have one on, I don't know, out in South Old Bridge, off Englishtown Road. I'm sorry, I can't hear you. Texas Road? The senior housing that we have off of Englishtown Road, there's a senior housing building. I
The
don't
new
remember
one, that's the Woodhaven one.
What is it? Not
Woodhaven.
Woodhaven, no.
Then-
Anyway, there is one. out
If
there.
there is
that-
an
there's one-
older one, unless
The over 55, that's Woodhaven. The one that's on Texas Road?
It's not Woodhaven, no. I don't know, I can't remember the road it's on, but, and there's also one by the hospital.
Old Matawan Road, the one that went up for Vision. That one you're talking about?
No, it's off Englishtown Road.
are you talking
Can't remember
about
the
the?
road. I just wonder if we got credit for those.
So yes, I know there were a couple of age restricted housings that got credits for the second round. However, we do not get credits for it again unless their deeds have expired and they have got another extension for 30 years. So we can't get double credit. So once they expire, just like Rotary Housing, we never use the remainder credits. But there are some municipalities wherein the deed restrictions have ended in this round and they have signed up for new agreements to be deed restricted for the next 30 years. Then you can get new credits. There are some projects that will be eligible for credits the same way in our next round. But in this round, we don't have anything where we can get
I was
credits.
just wondering, and then there's a senior housing over by the hospital.
Yes, I checked that because I think it's like the Costello and then there is Mayor Manor or
Mar Manor and
More
Costello.
Manor. Yes, there were a couple of projects, but
That's on, those are right off 18, right near the hospital.
right near the hospital. But those, they are still within their 30-year restriction. They haven't expired, so they haven't extended. Once they extend is then we can use them for credits. So probably the next round.
Any other questions? Okay. I'll open up to the public.
Good evening, members of the board. For the record, I'm Anthony Zarillo from the law firm of Willen, Scopen, and Spitzer. I'm here on behalf of K. Nanian, who Mr. Sordillo and Ms. Swan have adequately stated is one of the objectors to the Housing Element Fair Share Plan and the contract purchaser of the Transit Village site. I'm here just to state for the record that K. Nanian, in accordance with the court's order, is continuing with its objection with the understanding that we're going to continue to work with the township towards a potential settlement for the Transit Village site as to an appropriate design and density. It's KOF's continuing position that the 1,500 unit designation that's provided to it is not economically feasible and therefore doesn't provide a realistic opportunity for the development of affordable housing. That, again, understanding that in accordance with the court's order, we'll continue to work with the township as we have been towards an equitable, a just solution to that issue.
Thank you. Are there any questions for this gentleman?
Well, he's not providing testimony, he was just providing his comments.
Okay. Okay. Well, thank you.
Thank you.
Can I just ask another question? Yeah, I've been around too long, I think, so I remember way back when. But there were times when you could give money instead of building, the builders could donate money.
That's no longer permitted. That
We
was,
don't allow that anymore?
they didn't allow it in they took it out in the third round, and
Oh.
they continued that out. Yeah, that was something that was utilized in the first and second round.
Yeah, so I just wondered, do we still have any of that money? Probably not. I just wondered if that money is being spent.
And any money that we would have received for that would have been in our trust fund, which is what Nina testified to at the end as to what those balances are. So if we did receive any money from that, or if we paid any money from that, it would have came from that same trust fund. So that's still that balance would
But we don't, they
identify
don't
that.
have that option anymore.
No,
That is-
no.
Okay, seeing no other hands, no other people, I close the public section.
Yeah, Mr. Chairman, there's a resolution that's on the agenda that was circulated that approves and adopts the amended housing elephant plan, if that's the desire of the board.
Okay, well, your presentation was quite complicated, a lot of numbers, sounds good. I'm looking forward to approving it, so, have we any questions about the resolution? Okay, can we get a
Motion to adopt.
motion to adopt? Okay,
Mr. De Palma,
Yes.
Mr. Talama,
Yes.
Ms. Cannon,
Yes.
Mr. Petty,
Yes.
Ms. Masella,
Yes.
Mr. McIsaac,
Yes.
Mr. Brennan,
Yes.
and Chairman Lauer.
yes. Thank you.
Thank you.
Okay. Open it up to general public comments. Seeing no hands, close that. Looking for a motion to adjourn.
Motion.
Second.
All in favor?
Aye.
Aye.
Any opposed?